Hello, and welcome to California Gun Law. I'm your host, Don Hammond, coming to you from SHOT Show in Las Vegas with an update on the Wolford v. Lopez case in the United States Supreme Court. The Supreme Court heard oral argument this morning, and it was fascinating. I listened to the entire 2-hour hearing and then put together a script for this video just for you loyal subscribers. This is the case challenging Hawaii's law prohibiting concealed carry on private property that is open to the public unless you get explicit permission from the property owner. This is often called a vampire law. We'll discuss how the oral arguments went and how the decision will impact California residents. And keep an eye out for our collaboration with William Kirk at Washington Gun Law coming to you from SHOT Show this week. I'm a licensed California attorney and a shooting instructor. I regularly help teach the 16-hour class that's required to get a concealed carry license in California. On this program, we provide education on California's complicated web of gun laws so that responsible gun owners like you can better understand how to lawfully exercise their rights. California has a complicated web of firearms laws and regulations, and there are lots of traps for the unwary. We want to help you do it right so that you won't need our criminal defense legal services. Today, I'll discuss updates at the United States Supreme Court regarding the Wolford v. Lopez case, challenging a Hawaii law that prohibits licensed concealed carriers from carrying guns on private property without the express consent of the owner of that property. The court heard oral argument this morning with 3 different attorneys arguing various aspects of how the Second Amendment applies to Hawaii's law. In a surprise to no one, the Ninth Circuit upheld Hawaii's law, and now the Supreme Court granted review, and the issue is being submitted after today's oral argument. This Supreme Court case is especially important to California because the challenge to California's sensitive places law at Penal Code Section 26230, which is a part of Senate Bill 2, is currently sitting at the Ninth Circuit. It was set for a hearing in March, but that case was stayed pending the Supreme Court's decision in Wolford v. Lopez, which hopefully will come this June. At the hearing today, gun advocates were represented by Attorney Alan Beck. The United States government was represented by Deputy Solicitor General Sarah Harris, and the state of Hawaii was represented by Neil Katyal for the state's Attorney General. Several of the justices made their positions very clear, but I think we'll get a win here when the decision comes out. Hopefully it'll be published in June. The gun owner's attorney, Mr. Beck, argued first and struggled with some tough questions from Justices Sotomayor, Jackson, and Barrett. Justice Ketanji Brown Jackson, in particular, doesn't see this as a Second Amendment case, but rather as a property rights case. She says it doesn't even implement the Second Amendment. If a property owner can exclude anyone from their property, then they also have the right to exclude people who are carrying guns, or so goes the argument. In many of the questions, there seemed to be some confusion about places open to the public versus private homes, and conflating the rights of property owners in these very different situations. Attorney Beck pointed out that over 96% of Hawaii is currently off limits for concealed carriers because of a web of law declaring sensitive places and this private property restriction. Justice Sotomayor pointed out that that number includes state parks, government buildings, schools, and other places where the state owns the land and probably has a different right when it comes to excluding people. Of course, none of that is at issue in this case. We're just talking about private property owners. There's a lot of talk about historical analogs. The state and Justice Jackson in particular want the court to use black codes from Louisiana in 1865 to show historical analogs of Hawaii's law. Those black codes prohibited black people from carrying guns precisely to thwart their Second Amendment right to self-defense. Our side and Justice Thomas pointed out that those laws were unconstitutional from the start, and therefore they are outliers that should not be considered in an analysis under the court's Bruin decision. The other laws that may serve as historical analogs are anti-poaching laws that existed at the founding and outlawed people from hunting on other people's land without permission. Several justices don't seem to believe that this is sufficiently analogous to Hawaii's law. Justice Alito pointed out that no other items are prohibited without express permission from the property owner, including knives, machetes, and other dangerous objects. Justice Kavanaugh referenced the Heller decision and the status of the Second Amendment as not being a second-class right. There was a lot of talk about restrictions on the First Amendment versus the Second Amendment and how we treat those things differently. For example, there was a question as to whether the state can prohibit political candidates from approaching people's doors unless the person posts a sign allowing the candidate to approach. The obvious answer is no. Political candidates have to be able to walk up to your door like anyone else. The United States was represented by Deputy Solicitor General Sarah Harris. She argued very persuasively in favor of gun owners and against the Hawaii law for the United States government. Many of the questions went off topic to whether a state can regulate carrying in a church from Justice Sotomayor, or if a state can prohibit carrying at gas stations in the face of a rash of gas station robberies by Justice Barrett. And then we saw more softball questions from Justices Thomas, Gorsuch, Alito, and Kavanaugh. It was refreshing to see the federal government take a pro-2A stance at the highest court. Attorney Neil Katyal argued for the Attorney General of the state of Hawaii, defending the law at issue. He says there's no assumption that an invitation to enter private property includes an invitation to bring a gun. Justices Thomas and Roberts took issue with that, of course, and Justice Kagan tried to distinguish First and Second Amendment rights, arguing that a mall owner can prohibit distribution of leaflets without consent, so they can also prohibit carrying of firearms without consent. Justice Alito pointed out that a restaurant owner cannot prohibit specific shirts in most cases, so they also should not be able to prohibit people from carrying guns. He drew out the distinction between the First and Second Amendments and how we treat those two constitutional amendments very differently. There was some talk about the California law in particular and how it differs from the Hawaii law at issue in the case. In the Hawaii law, verbal consent is sufficient, whereas in California's version that is currently on hold, the property owner would have to post a sign allowing people to carry guns on their property. Overall, it looks like we have Justices Roberts, Kavanaugh, Alito, and Gorsuch very firmly on the gun owner's side. I think Justice Thomas will join them with a detailed concurrence, and Justice Barrett may also join the majority here. Justices Jackson, Sotomayor, and Kagan will be a very tough sell, and they'll be in the dissent. Justice Kagan sees this as a property rights case, not a Second Amendment case. Justice Sotomayor would overturn Bruin on its face. She thinks that test is unworkable. We might see some favorable language in Justice Kagan's dissent, as she seems to believe that this law passes Bruin's Step 1, and that there's a struggle at Step 2 regarding the historical analogs. So that's my summary of what happened this morning. We'll look out for a decision in June. We're still optimistic that the Supreme Court will accept the Duncan v. Bonta case regarding standard capacity magazines. The case was redistributed for the conference last Friday, January 16th, but we haven't seen any word on what the court's going to do from there. They can grant review, redistribute it for the next conference, or they could deny review. We'll be keeping an eye on it. What do you think? I think the vampire rule is doomed. Let us know your thoughts in the comments. And head on over to cagun.law for legal updates and to pick up some cool merch to support the cause. And look out later in the week for my collaboration with Washington Gun Law's William Kirk. I'm Don Hammond at California Gun Law, and we'll catch you all next time. Stay informed, stay legal, stay safe.